Hello guys, welcome to this episode of Contract Law. So today we are going to handle some of the ways of terminating a contract. So one of the ways of terminating a contract is known as performance. So when all parties have received the release of advantage from the other side, this is known as now performance. All the parties or in a contractual arrangement have received the benefits from each other. We have what we call rule of Carter versus Powell. This is a case law, and this rule simply specifies that obligations under the contract must be absolutely completed in order for the contract to be discharged by performance. But there are exceptions, because applying the rule in Carter versus Powell case ruthlessly may lead to injustice in some instances. So the court makes some exceptions. One of these exceptions is divisibility rule, and this simply states that if a promise can be neatly divided, then a person is paid for those bits that they did successfully. Secondly, we have what we call the minimus rule, or also known as the doctrine of substantial performance. So this de minimis rule states that if an obligation has been substantially performed, some trifling failing cannot justify refusal to pay. So we also have something known as part performance, that says that if a party accepts a part performance of an obligation, they cannot rely on the rule of Carter versus Powell. That is now on performance. That is one way of terminating a contract. Secondly, we can terminate a contract by what we call agreement. So for example, when you get into maybe a rental, there is an agreed duration of time. So if the expiry of that day comes, you may vacate or renew and go for more days. That is something that you agreed with the owner. So we have also two types of agreements. One is failure of a condition precedent. If a condition precedent fails, then the contract cannot commence at all. So a condition precedent is a condition allowing for a contractual structure of behavior to proceed. So if a condition subsequent occurs, then this ends the contract. A condition subsequent occurs especially when the contract is under what I might call implementation. So something comes and now the contract cannot happen anymore. So if something occurs in the middle of a contract, the contract is terminated. This is known as condition subsequent. The other one that I talked about is condition precedent, which says that if something does not happen, then there will not be a contract at all. So if something does not happen before the contractual behavioral activities that take place, then that is known as condition precedent. So we also have termination by release, where parties can induce to end their contract. So we also have another type of termination known as termination by frustration. So in termination by frustration, this means that frustration occurs. For example, an external event happens which is neither the fault of the parties, which change the nature of contract obligation and really destroys the contract. For example, the destruction of the subject matter will render a contract void because the subject matter no longer exists. A contract, we also have to note that a contract is not frustrated just because it becomes more expensive or difficult to complete. Frustration only affects future obligations. So we also have fourthly, a way of terminating contract is known as termination by breach. This is where one of the party does not keep their promise. So there are two ways of breaching, or two types of breach. One of them is repudiation. Repudiation occurs when a party walks away from obligations without completing them. In most cases, these are contractual obligations. Secondly, we have what we call anticipatory breach. This is where the other party sees that the party is going to clearly breach the contract. So you don't have to wait until the damage is done. You can simply claim anticipatory breach and instead stop behavioral activities that will end up in the end causing damage. Thank you for watching this video. Like, share and subscribe.